indication of that on your screen. Okay, well, people are coming in slowly. I think we can get started in the meantime.
On the record or off?
Let's just start off the record. So for you, those of you who don't know, I'm Mike Newmark, the Administrative Law Judge for the PSC. And we are going to do the party session for NSPW. So it's pretty typical to our process, and the way I tried to indicate in my email to parties is that before we take the first witness, that'll be time for appearances and questions about first of all, the offered evidence list. We'll look at whether it's correctly reflecting documents being offered. Then we can review comments that I've indicated on the list in terms of filing corrections. And we can also hear any pending motions or any other comments, concerns from parties and staff. We can also identify witnesses that may be excused without making an appearance, and who would then file their documents, verify their documents by affidavit. Next, we'll probably do that right after we do appearances, just to cut that short for them. So any questions about that? Okay, it looks like we've slowed down the number of people joining us, so hopefully won't have too many interruptions. Okay. Let's get on the record. Good morning. This is docket 4220 UR 126, the application of Northern States Power Company for authority to adjust electric and natural gas rates. This is Michael Newmark, the Administrative Law Judge for the PSC. We're here on Zoom with the party hearing session. We also conducted a public hearing session on September 11th, and we're also accepting written public comments up until Friday, September 29th by US mail and also through the Commission's website. We have 6 comments on file so far. So the details on how to make a comment are on the notice of hearing, which is displayed on the screen share and will be available on the YouTube recording of this hearing. Also, it appears on the commission's website. So we can switch over from notice to service list. So we need to take appearances on the record. So this may be slightly dated. I'm not sure if ChargePoint is still participating. Or I know we got a notice in Madison Gas and Electric that they dropped out of that case. Is anyone here for ChargePoint? No, okay, didn't think so. All right, well, we're just going to go through the list alphabetically. Who's here for Cub? Unmute.
Pardon me, Your Honor. Kara Ferris for Cub.
Okay, thanks. NSPW.
For NSPW, Jordan Hamiden of Michael Best and Friedrich, and also Mike Capping, Principal Attorney at XL Energy.
Okay, yeah, got that there. Great. Public Service Commission of Wisconsin.
Kara Kuntz, Assistant General Counsel for the Public Service Commission of Wisconsin.
Okay, Renew Wisconsin.
Hi, Your Honor. Ori Walsvik on behalf of Renew Wisconsin.
Okay, welcome.
Thank you.
And Walmart.
Good morning, Your Honor. Stephen Lee from the law firm of Stillman, Thomas, and Battle, appearing on behalf of Walmart.
Great. And Wig.
Good morning, Your Honor. Steve Heinzen appearing for the Wisconsin Industrial Energy Group.
Great, thanks. All right, that's all we have for appearances. Shut that down. So we can move on to this offered evidence list for the purpose, I guess, first of all, we want to just see if there are witnesses we can excuse, have them verified by affidavit. I was trying to track the emails that came in from parties and staff. Is it simply witness Dahl that has cross at this time?
Judge, yeah, that's correct. We would tend to prefer, since all of our witnesses have made time this morning, to take the few minutes to put them up on the stand and orally verify their testimony and avoid some paperwork and notarization and filings.
Perfectly appropriate. I appreciate that that process. So we'll take all the NSPW witnesses. How about and so there's still only cross for Dahl.
Judge Newmark, the Public Service Commission no longer has cross examination for Mr. Dahl.
Okay, all right. I had a feeling that was going to happen. And any other cross for any other witnesses?
I just want to clarify too, Judge, that we've got 5 witnesses, well, including Mr. Dahl. There's no cross on his written sur rebuttal that was filed. So we have 4 witnesses who are going to be putting some oral sur rebuttal on today. So, of course, I respect all the parties' rights to cross-examine the information put in the record through those means.
Yes, okay, appreciate that. So let me ask a different way. Any witnesses that we can excuse? Starting with the Cub witnesses, any questions for them?
Your Honor, oh, excuse me.
Yeah, go ahead.
I think that we will just verify here today if that's
fine.
fine.
Same with Renew, or do you want to? Probably easier.
Yeah, Your Honor, can I ask a clarifying question? As far as the affidavit goes, looks like we have some corrections we need to make. If we verify today, will we have to refile an affidavit for the corrections?
No, if you verify live, then you verified it with the corrections. So there you go. There's your carrot.
Okay, Mr. Say is here and can verify today.
Perfect. All right. How about Walmart?
Thank you, Your Honor. I think we'll just verify by affidavit if that's acceptable.
Yes, that's fine. And then there are no questions for those witnesses. Just want to be sure we know.
I think that's correct, Your Honor. And if I can ask one quick question, our one witness, Mr. Teague, will be on vacation next week. Is it acceptable that he files his affidavit the following Tuesday when he's back in the office and able to get it completed?
Oh, because there is a refiling. Yeah, Tuesday's fine.
Okay, thank you, Your Honor.
And commission staff usually they appear, so expecting them to do so. Okay, all right. So that was very different than what usually happens. So that's fine. All right,
Your Honor.
so, Yes.
I'm sorry, just to check in with Weeg, I believe no one has crossed for Miss York.
Okay.
And so I would like to have hers come in by affidavit as well, but if I can just ask Jordan first. Jordan, is any of the service to rebuttal responsive to anything that Jessica York testified to?
I do not think so.
Okay. Okay, so I would like to have her, thank you for that, Jordan, but we'll have her testimony in by affidavit then, Your Honor. Thank you.
Okay, so based on that representation, she can be excused.
Right.
File that by affidavit.
All right, thank you.
So, okay, that's fine. So let's, and that's the only one I'm expecting then by affidavit. Did I get that right?
Both of Walmart's witnesses, Your
Oh,
Honor.
Walmart's, yes.
And if
Okay,
they can
great.
both be excused.
Yes, is there, maybe I read the list wrong. So we just have two.
Yes, correct. Mr.
All right,
Fernando
okay.
and Mr. Teague.
That's what I did wrong. I skipped over Wig and just, yeah, thought you had three witnesses for some reason. I don't know why. Okay. Okay, great. So just briefly then, we can go off the record for questions on the comments. Any clarifications we need?
Speaking for applicant, NSPW, all of your instructions seem very clear to us, and we're prepared to make all those filings, including the separate communication about Ms. Irwin's testimony and having that letter filed separately. And we'll be prepared to refile all of those things as instructed a few days after the hearing today.
Okay, great. Yeah, thanks. Yeah, actually, Tuesday, you were saying, so actually affidavits aren't due until Wednesday in this case, right? Because today's Friday, so you have 3 days to file all of the all these post-hearing documents. So that's already part of the order. So you'd find that in the scheduling order, the deadline for that.
Okay.
It's also, you can find it as a you can calculate it, I guess, if you look in the facilitating matters order, it says that these are due 3 days, 3 working days after the hearing. So yeah, everyone has actually till Wednesday to refile and file affidavits.
Your Honor, this is Stephen Lee on behalf of Walmart to clarify Walmart's request. Since
Okay.
Mr. Teague will be on vacation all of next week.
Right. The next
The
Tuesday.
following Tuesday, October 3rd.
Got it.
Okay.
Okay, so that decision still stands.
Okay. Thank you, Your Honor.
It's all of the details, right? So how about Cub? Any questions?
We did have one question, Your Honor, regarding witness Callan's rebuttal and his exhibit 6.
Yes.
So that makes sense. We're happy to move his discussion of the methodology into the testimony. I just was a little unclear on your reference to Schedule 2 because that is an Excel spreadsheet, and I think maybe you just intended to refer to Exhibit 1.
Probably. I was maybe thinking of another case where
Sure.
there was 2. Yes, you're right. Just
Okay.
Just Schedule 1 needs to be incorporated into testimony.
Thank you.
Thanks. Okay, and then we'll just move down for a renew. Do I have any? No, I think you got away with without any corrections. So
I think there's
Oh,
2, Your Honor.
oh, there is. Okay.
And I just want to make sure I'm understanding. It looks like we just need to include the citation disclaimer from the facilitating matters order.
Mhm.
For the direct, my inclination was to place that disclaimer after the footnotes that contain. And then for the exhibit, I was wondering if it would be possible just to include that disclaimer in the cover page.
Yes, and that's actually what you're supposed to do.
Okay.
Yeah,
Okay.
that's how the order reads. So yeah, and because, so let me just show this. So it actually enforces another detail, which is if you're offering a document that already exists, it's not being created for the case, or it's not being generated by the witness like an Excel spreadsheet, that kind of thing. But a document that you've found online or has been provided to you in discovery, that kind of thing. You shouldn't be placing any markings on that document. You want to give it to the commission as you found it. So that would mean you wouldn't want to place any of those disclaimers on the page. You also wouldn't want to put page numbers or the document, the exhibit marking. None of that stuff goes on this original document that you've received. If you receive it with extraneous marks on it, there's nothing you can do about that. I understand. So you don't need to find the fresh version, but just give us the one that you have without any markings placed on it by the party.
That was my concern, Your Honor. Thank you.
Yeah. Okay, good. All right. Walmart, any questions?
No questions, Your Honor.
Okay. And WIG?
Yes, thank you, Your Honor. I do have a couple of questions in connection with the direct testimony of Miss York.
Yeah.
And I guess I'll start with the first one, which is, as I understand it, it is at page 5, line 6. Now, I'll give you a moment to pull that up.
Mm-hmm. Yeah.
Okay, and I understand your correction here to say that we should add the citation disclaimer. The document's not cited in the first instance, and so I guess my first question is, should we drop a footnote there citing, I don't know, to the PSE ref number, followed by this is not record evidence?
If you'd like to put the ref number, you can. And the idea that the disclaimer kind of just negates all of that for purposes of what the commission can see. So if you want to be more explicit about which document it is, that's fine with me.
But I'm sorry. I need not do that though. I can just drop the disclaimer there.
You can, yes.
Okay.
Yeah, that's
Okay.
we haven't gotten that far yet. That may happen someday, but I'm not going to tell you have to do that.
Okay, no, I appreciate that. Thank you. And then I do have so the next one is page 6, footnote 2. And I just want to make sure, because at the bottom of page 5, there's, we have a footnote to direct testimony. Yeah. And then at the bottom of page 6, again, here is a response, or we reference a response to a data request. Mm-hmm. And I guess and that's footnote number 3. So I just am asking, I guess, clarification is that, am I supposed to, are you asking that we put a disclaimer to this footnote number 3 that's on page 6? And I guess in advance, also add the PSC ref number.
Oh, okay. I see. I put that in there to act. Oh, so the PSC reference numbers. Yeah, I guess I don't know. This could have been cut and pasted from something else, or I'm not sure exactly with all the cases going on at once. But
sure.
Well, the data request, again, that's a similar situation where you'd want to add the disclaimer. The PSC reference number isn't required. I mean, people can put it in.
Okay.
That should. So I'm not sure where this footnote 2 came in, but I guess what I wonder is, where I'm asking people to put in the PSC number, where it should really go in is when there's a commission order citation. So that's something that to properly cite an order that's on IRF, I want the number on there. So that's been in. So if you see that in the corrections, it should be referring to an item that's making a citation to a commission order. And that's something that's not by accident. That's how it should be.
Okay, then. So I guess I'll just confirm then. So we just need the citation disclaimer in connection with the note on page 5, line 6, and then for that footnote number 3.
Yes.
Okay. Thank you so much.
Okay.
I don't have any further questions. Thanks.
Okay. All right. Sounds good. And staff, we could do some of that offline if you need to, but any questions at the moment?
No, Your Honor.
All right. Okay, so let's get on the record. So I can, so we discussed the offered evidence list and the corrections that were made to filings that I indicated and shared with parties. And so as we've discussed these corrections and have some more clarification on them, the documents that are identified in the offered evidence list will be received into the record pending verification and corrections. We also have a couple more documents that we'll need to add to the list, but we'll get to that. Just wanted to make sure we did officially place those documents in the record. And we're on the record, right?
Yeah.
Okay. Thought I said let's go off for a while. Okay. Okay. So we've done that. Anything else we need to discuss before we take our first witness? No. All right. Well, let's get started then. We'll have the applicant call its first witness.
Thank you, Judge. NSPW's first witness will be Ms. Asherman.
Okay. So I think what we'll be doing now at this point is spotlighting the NSP witness box here for everyone. And the way I understand that'll work on YouTube is that your video will be the one people will be seeing until we unspotlight you. So just be aware of that. You're in your not seat. No matter who's talking, it won't switch back and forth. Okay, so let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Good morning. Please state your name for the record and spell your last name.
Good morning. My name is Mara Ashman, spelling ASCHEMAN.
Did you file or cause to be filed written direct and rebuttal testimony in this proceeding, together with exhibits that have been marked Exhibit NSPW Asherman 1 and Exhibit NSPW Asherman 2?
Yes, I did.
Were the answers you provided in that testimony and the information you provided in the exhibits true and accurate to the best of your knowledge?
Yes.
Thank you. And I don't believe there's any cross-examination for this witness.
Okay, just double check here. Any questions? All right, thanks very much. You're excused.
Applicant's next witness will be Ms. Patty Martin, and I believe she's already on.
Okay. So on a different screen. Okay, so I can.
Yeah, she's on a different screen, Judge. The one we're using for the NSP witnesses are the ones that are co-located with us here.
Okay, I get it. So let's just go off the record for a second. I'm just going to need to could you turn on that witness screen one more time? I think I need to unspotlight.
You're asking me, Your Honor?
Maybe I can do it here. Not sure if I can. Oh, I can do it from here. No, nothing's needed.
Okay.
Yeah.
All right.
It's the infamous right click will get you many places you didn't know you could go. All right. So great. Let's get on the record then. So witness Martin, please raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
Sure. My name is Patricia Martin, spelling MARTIN.
Thank you. Did you file or cause to be filed written direct and rebuttal testimony in this proceeding, together with exhibits that have been identified as Exhibit NSPW Martin 1C, 1P, 2, 3, and 4?
Yes, I did.
Were the answers you provided in that testimony and the information contained in your exhibits true and accurate to the best of your knowledge?
Yes.
Thank you. Judge, I don't believe there's any cross-examination for this witness.
Okay, any questions? Okay, thanks. You're excused.
Thank you.
Our next witness, Your Honor, will be Mr. John Goodenough, and he also, I believe, is signed on separately.
Okay, yeah, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? Okay, I'm not hearing you. Something's wrong there. Yep, just take this off the record and we'll figure it out.
Is this better?
Yes, oh, sounds good.
Great.
Okay, so I'm just swearing you in. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, great. Go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
My name is John Goodenough, spelling Goodenoughh.
Thank you. Did you file or cause to be filed written, direct, and rebuttal testimony in this proceeding together with exhibits that have been, an exhibit that's been marked as EX NSPW Goodenough 1?
I did.
Were the answers you provided in that testimony and the information provided in the exhibits true and accurate to the best of your knowledge?
Yes.
Thank you. Judge, I don't think there's any cross-examination for this witness.
Thank you. Any questions for the witness? No? All right, you're excused. Thanks.
Your Honor, the next witness for applicant is Ms. Annie Delva.
Raise your right hand and yeah, there you go. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
My name is Annie Delva, spelling Dellva.
Thank you. Did you file or cause to be filed written, direct, and rebuttal testimony in this proceeding together with exhibits that have been marked EX NSPW Delva 1C and 1P?
Yes, I did.
And were the answers you provided in that testimony and the information contained in your exhibits true and accurate to the best of your knowledge?
Yes.
Thank you. I have one additional question for Ms. Delva on Sir rebuttal. Ms. Delva, have you reviewed the rebuttal testimony of PSCW staff witness Mr. Ritzema?
Yes, I have.
And what is your response to Mr. Ritzema's proposal in his rebuttal testimony to use a 24-month average for purposes of determining MISO costs and credits?
Mr. Ritzema's rebuttal proposal to use a 24-month average for MISO costs would be acceptable to the company because it results in a forecast that is much closer to the company's position to use costs since April 2021. However, as already stated, we believe that a period that is an increment of 12 months is not necessary, and the commission should evaluate what the reasonable period is in each fuel cost plan.
Okay, thank you. I have no additional questions for this witness.
Okay. Any questions for the witness?
No questions.
Questions? All right. Okay. Well, hearing nothing then, you're excused. Thanks very much.
Thank you.
Your Honor, the applicant's next witness will be Mr. James Arand, and he's coming in to sit down now,
Okay.
and he's present with us in Eau Claire.
Okay. Yes. Thanks. Great. Thank you. All right. I'm just going to spotlight you here. All right. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
My name is James Arand, spelling Aurand.
Thank you. Mr. Arand, did you file or cause to be filed in this proceeding direct testimony and an exhibit that's been marked exhibit NSPW Arand 1?
I did.
Were the answers you provided in that testimony and the information in the exhibit true and accurate to the best of your knowledge?
It is.
Your Honor, I have no further questions for this witness.
Okay, any questions? No, thanks, you're excused.
Your Honor, our next witness will be Mr. Nickel, and he is remote, so you should have a separate screen for him.
Okay, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, great, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
Good morning, Chad Nickel, Nickell.
And Mr. Nickel, did you file or cause to be filed in this proceeding direct and rebuttal written testimony?
Yes, I did.
And were the answers you provided in that testimony true and accurate to the best of your knowledge?
Yes.
Your Honor, I have no further questions for this witness, and I don't believe there's any cross-examination for this one.
Okay, any questions?
No
Right.
questions.
No question. Okay, you're excused. Thanks very much.
Thank you.
Your Honor, the applicant's next witness will be Ms. Deborah Irwin, and she's remote.
Okay. We've taken off the spotlight. Yes. Okay, great. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
Deborah Irwin, Erwin.
Thank you. And did you file or cause to be filed written direct and written rebuttal testimony in this proceeding together with exhibits that have been marked EX, NSPW, Irwin 1 and 2?
Yes.
Were the answers you provided in that testimony and the information contained in those exhibits true and accurate to the best of your knowledge?
Yes.
Your Honor, I have no further questions for this witness, and I don't believe there's any cross-exam.
Any questions for the witness?
No questions.
Okay, thanks. You're excused.
Your Honor, the applicant's next witness is Ms. Julie McCray, and she's here with us in Eau Claire.
All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
Julie McRae, last name spelled McRea.
Ms. McCray, did you file or cause to be filed written direct and rebuttal testimony in this proceeding together with an exhibit that's been marked Exhibit NSPW McCray 1?
Yes.
And were the answers you provided in that testimony and the information provided in that exhibit true and accurate to the best of your knowledge?
Yes.
Your Honor, I have no further questions for this witness, and I don't think there's any cross-examination planned.
All right. Any questions for the witness?
No questions.
Okay, thanks very much. You're excused.
Thank you, Your Honor. It's going to take 1 minute because our next witness is also here with us in Eau Claire. We just have to switch seats, and that will be Mr. Moldenhauer.
Okay.
And he's here.
There you are. All right. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
Ryan Moldenhauer, Moldenhauer.
Thank you. Did you file or cause to be filed written direct and written rebuttal testimony in this proceeding together with 3 exhibits that have been marked Exhibit NSPW Moldenhauer 1, 2, and 3?
Yes, I did.
And sir, were the answers you provided in that testimony and the information you provided in the exhibits true and accurate to the best of your knowledge?
Yes.
Your Honor, I have no further questions for this witness, and I don't believe there's any cross planned.
Okay. Well, let me just check here. Any questions for the witness?
No questions.
Okay. Thanks very much. You're excused.
Thank you. Your Honor, our next witness is remote, and that would be Mr. Jim Coyne.
Just hang on a second. Okay, see you there. All right, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good morning, sir. Could you please state your name for the record and spell your last name?
It's James Coyne, Coyne.
Thank you. Sir, did you file or cause to be filed in this proceeding written direct and written rebuttal testimony together with 4 exhibits that have been marked Exhibit NSPW Coyne 1, 2, 3, and 4?
I did.
And were the answers you provided in that written testimony and the information contained in your exhibits true and accurate to the best of your knowledge?
Yes.
Okay, Your Honor, I have some further questions for this witness in the form of sir rebuttal.
All right,
If I may proceed.
go ahead.
Mr. Coyne, you've addressed several aspects of Mr. Kimes' evidence, witness for Cub in your rebuttal testimony, but he filed a substantial piece of sir rebuttal testimony several days ago. Have you had an opportunity to review that?
I have.
And were you able to specifically to review Mr. Kimes' interpretation of the Supreme Court's Hope decision on page 15 of his sir rebuttal testimony?
I did.
And do you have any response to that interpretation of Mr. Kimes?
I do. Thank you. While I'm not an attorney, of course, in my view, Mr. Kimes' interpretation of the Supreme Court's Hope decision is overly narrow and selective. Mr. Kimes cites a few sentences of this very lengthy decision, but in my view, leaves out some very important context. Among the sites that Mr. Kimes refers to, the Supreme Court is talking about the Federal Power Commission's decision, which is the source of the Hope Supreme Court decision. And he cites to the fact that the FPC reduced Hope's net income by 62% and establishes that that would be the equivalent of reducing NSPW's ROE today to about 4%. And goes on to cite that the court noted that this would not support, that it would not support market valuations, but it nevertheless found that the FPC's authorized returns could not be condemned as invalid, even though they might produce only a meager return in the so-called fair value rate base. But the important context that I believe Mr. Kimes left out in the decision is that the Supreme Court rejected the use of a present fair value rate base that had been accepted by the Circuit Court of Appeals. But instead, the allowed ROE was set on an adjusted book cost rate base, and that was the source of the income reduction, and not some blatant disregard for a reasonable return or valuation impact as suggested by Mr. Kimes. Those same rate-making principles are applied today in Wisconsin, and that is to choose a return selected on an adjusted book cost equity rate base. The quote-unquote meager return mentioned by the Supreme Court in Hope referenced the return on fair market value rate base. In the same paragraph cited by Mr. Kimes, the court indicated in that connection, it will be recalled that Hope contended for a rate base of $66 million computed on reproduction cost new. The commission points out that if that rate base were accepted, Hope's average rate of return for the 4-year period would amount to 3.27%. But during that period, Hope actually earned an annual average return of about 9% on the average investment. So it was the foundation of how the rate base is computed in Hope that was determinative, and not a meager return as suggested by Mr. Kimes. And that was the source of the income reduction also cited by Mr. Kimes, but also without the context. In my view, no reasonable interpretation of the Hope decision would suggest that regulators should ignore the impacts of their decisions on capital markets, as they ultimately affect both access to and the cost of capital.
Thank you, Mr. Coyne. Now, pages 2 and 13 of Mr. Kimes' rebuttal testimony, he asserts that regulators set allowed utility ROEs too high, not at the true cost of equity or not according to fundamental principles of finance. Do you have a response to that?
I do. I would observe that the cost of equity cannot be directly observed in the same way as the cost of debt or preferred stock. Various financial models have been developed in order to estimate the cost of equity, including the DCF model, the CAPM model, the risk premium model, and the expected earnings model, as I've used in my analysis. Each model has its strengths and limitations. These models are employed by experts and relied upon by regulators and are well-grounded in financial theory and practice. Two specific papers cited by Mr. Keim, and these are the Dunkel-Warner and Jarvis paper and the Rode and Fishbeck papers, suggest that there's a gap between the cost of equity and allowed ROEs set by regulators. But there are several problems with these papers. One, these papers rely on only one model, and that's the CAPM, to evaluate the relationship between bond yields and allowed returns. Secondly, they find that the CAPM alone cannot fully explain this relationship and deem differences between allowed returns and these bond yields to be excessive as measured by just the CAPM model. But they make simplifying assumptions and again, only use one model. So it's not surprising that they fail to explain the more complex relationship between capital markets and the regulatory process that determines allowed returns. So it's simply not credible to conclude that a simplified application of one model means that regulators are getting it all wrong. In my experience, regulators have the tools they need, relying on multiple financial models, credible inputs, and informed judgment to determine the cost of equity.
Thank you. Moving on, in Mr. Keim's rebuttal at pages 11 and 16, he appears to continue to support the view that regulators should set ROEs targeting a stock market to book ratio of 1.0. What is your response to that?
I addressed that issue in my rebuttal, but I would add at this juncture that this is an antiquated view, out of touch with modern stock markets, and no regulator I'm aware of pays attention to market to book ratios as a basis for setting allowed ROEs. To demonstrate the problem with this suggestion, the current market to book ratios for the broader market and utilities are currently, for the S&P 500, the current market book to ratio is 4.23%. For the Dow Jones Industrials, the market to book ratio is 4.48%. And even for my proxy group, the current market to book ratio is 1.78%. So to set a utility market to book ratio equal to 1 would mean about a 44% reduction in company income and a return on equity close to the cost of debt. It would clearly harm existing shareholders and also hinder the company's ability to raise both debt and equity capital. It's simply not a realistic proposal.
Mr. Coyne, on page 7 of his rebuttal testimony, Mr. Keim makes some asserts some criticisms of your evidence that you've provided. Do you have any responses to those criticisms?
I do in a few specific areas. Regarding the CAPM model, he indicates that I've used two methods for developing the market return on the S&P 500, which averaged 12.85%, according to Mr. Keim, and that both methods violate finance principles. That's just not correct. I used two different versions of the market return, one historic and one prospective. I did not average them or use 12.85%. The forward-looking estimate is based on FERC's accepted methodology for setting returns for U.S. transmission companies. The historic estimate is based on nearly a century of market returns reported by Kroll and widely used for such purposes in estimating the CAPM model. Both the historic estimate and the forward-looking estimate are used in my analysis. These are reasonable and broadly used assumptions. And although Mr. Keim suggests other lower estimates of market returns from a few sources should be used, including Kroll, which I in fact did use, there is no credible basis to suggest that they violate finance principles, or as he boldly asserts that I've chosen these because I represent, quote, a private interest that has an incentive to produce a higher number. Regarding the DCF model, Mr. Kimes states that I said in my rebuttal testimony that the long-run growth rate for any company in the economy, including utilities, approaches the GDP growth rate. And Mr. Kimes asserts that most companies, especially utilities, grow more slowly than GDP. But both these statements are false. I never stated that most companies grow at GDP, but this assumption is often used as a conservative long-term growth estimate in two-stage DCF models for utilities. I also showed on page 31 of my rebuttal that the proxy group companies used in my analysis have grown considerably faster than GDP over the last 12 years, and I therefore do not agree that GDP should serve as a cap on expected growth.
Thank you, Mr. Coyne. In his rebuttal at page 11, Mr. Keim continues to argue that Morningstar estimates Xcel Energy's cost of equity at 7.5%. Do you have any response to that assertion?
Yes, let me clarify this misconception of Morningstar. Morningstar does not estimate Xcel Energy's cost of equity. This is completely misleading. Morningstar uses a generic assumption for stock valuation purposes for all companies. And for those it views as having lower than average risk, it uses a discount rate of 7.5%, including utilities and all other low risk sectors. It only updates these discount rates periodically, and they are not company or even industry specific cost of equity estimates. If instead he had looked to Value Line, for example, who do create specific projected ROEs, they estimate for Xcel an ROE of 10.5% in 2024 and 2025, and 11% in 2026 through 2028. These are company-specific estimates from Value Line of earned ROEs.
Thank you. Now, Mr. Coyne, did you have an opportunity to review the rebuttal testimony of Mr. Tierney?
I did.
Now, at rebuttal, I believe page 1, Mr. Tierney contends that higher interest rates and higher inflation do not necessarily mean a higher cost of equity capital. Do you have a response to that testimony?
I do. This is a fairly strong but intuitive point. We see the effects of higher interest rates and inflation most directly in the CAPM and risk premium models that I've estimated because they're direct inputs. But we also see these effects reflected in utility debt costs. Since the Commission last approved the current allowed ROE of 10% for NSPW in November 2021, government 30-year bond yields have increased by 2.24%, and long-term utility bonds have increased by more than 2.5%. In light of these significant increases on lower risk Treasury and utility bonds, the requested 0.25% increase in ROE for NSPW meets any reasonable view of the market data. And as illustrated in my updated analysis, 10.7% could actually be supported, well above the 10.25% requested.
Okay, at page 2 of his rebuttal testimony, Mr. Tierney continues to defend his reliance on a terminal growth rate of 2.5% in the context of his DCF model. Do you have any response to that?
Yes, real GDP, and I put quotes around real from an economist's perspective, is not a good measure of long-term growth because it does not include inflation. That's the very premise of real. His stage 1 growth rates, whether earnings per share or dividend per share, all include inflation, which is projected by Blue Chip in 2024 at 2.3 to 2.5%. So to exclude that inflation is to significantly lower the estimate of GDP growth. If you were to include it, this would produce nominal GDP growth of 4.86% to 5.06%, well above Mr. Tierney's 2.5% growth rate. In my view, this is simply not realistic as utility earnings or a dividend growth rate, as both would unduly lower his resulting ROE estimates, or using the 2.5% would unduly lower his resulting ROE estimates.
Thank you. So having read all the testimony in this proceeding on the ROE subject, and in particular, the surrebuttal testimony submitted by Mr. Keim and Mr. Tierney. Do you have any concluding remarks with regard to your opinion on where ROE should be set in this proceeding?
I do. In my view, and based on the analysis that I've performed, the company's requested ROE of 10.25% on a 52.5% equity ratio is reasonable and fair. It'll provide the company with the financial strength required to meet its service obligations. And it's supported by my updated analysis, which, as I mentioned, would produce a mean result of 10.7%.
Thank you, sir. And one final question. Are the opinions that you've offered in this case provided to a reasonable degree of professional certainty in your field?
Yes.
Thank you. I have no further questions, Your Honor.
All right. Any questions for the witness?
Cub
No
has some,
questions. Oh, go ahead.
excuse me, Cub has some cross, Your Honor.
Okay, go ahead.
Good morning, Mr. Coyne. My name is Kara Ferris, and I'm the counsel for the Wisconsin Citizens Utility Board. And good morning. I have a few questions regarding your return on equity ROE testimony.
Okay.
And the first one, would you agree, Mr. Coyne, that cost of equity and ROE are different and that they measure different things?
From a standpoint of a regulatory proceeding such as the one that we're in now, I view them as the same. I view the commission's role as providing an allowed return on equity, and I view it as determining that allowed return based on the cost of equity. So I see the cost of equity, which I have measured, as being the input to the commission's determination of what the allowed ROE should be. So I see them as being equivalent, although one begets the other.
So are there other considerations in determining an ROE outside of the cost of equity?
Well, for any commission, one starts with one should start with financial analysis using the market inputs that are available in the traditional models that we use to estimate the cost of equity. But as I indicated in my comments to counsel, you cannot, it's not a precise measurement. You can't say with certainty that this is the number. Inevitably, it's a range that you estimate using reliable models and inputs. So inevitably, informed judgment is required by a commission to actually set the allowed ROE. We can provide estimates of what that cost is, but ultimately the commission determines from within that range where it's going to set it using its own informed judgment. And I believe that's appropriate.
And just to clarify what you mean by informed judgment, do you mean policy decisions?
I wasn't referring to policy decisions. By that, I was referring to other data that the commission might take into account, such as allowed returns in other jurisdictions, or in the case of this commission's determinations. In the past, I know it's exercised a policy it calls gradualism in implementing that informed judgment. So that's what I meant, as opposed to policy decisions per se, which could be much broader.
Okay. Mr. Coyne, would you describe cost of equity as a market-based value?
Yes.
And would you also describe ROE as a market-based value? Or could it be better described as an accounting book value?
Well, you're raising a few different issues there. Return on equity is something that has a few different dimensions, and let me describe three. The first dimension is that we try to estimate the forward-looking required cost of capital, and that's an ROE estimate. Based on those estimates, the commission would set the allowed ROE. A third element of that is what the utility actually earns, and that's the earned ROE. And I think that all three of those are important to recognize. They can all differ, but the first should lead to the second, but the third is a result of the commission's ability to actually earn that ROE based on its own operating efficiencies, incentives built into its rate program and things of that nature.
Okay, so forgive me, just to clarify. So you're positing an ROE, an estimated ROE, and an earned ROE. Those are the three ROEs?
An estimated ROE, an approved ROE,
Approved.
and an earned ROE.
Okay. Thank you for that. Mr. Coyne, are you arguing that an ROE reduction can make it difficult for an investor-owned utility to attract capital?
It depends on the degree of the reduction. Any change in the cost of the allowed ROE is typically noted by both equity analysts and bond rating agencies. The greater the degree of change in either direction is more likely to have an impact than, say, a small change.
And when you say noted, do you mean in communications and in reports that those analysts produce?
Yes, and those are the same reports that investors actually consider as they're considering whether or not to invest in companies such as the parent company of NSPW and other utilities. And what they're looking for is a risk-adjusted return that's justified for that company based on its risk profile and what it could earn elsewhere. Ultimately, the markets work such that investors are considering the opportunity cost of investing in one company or the other. If they could earn a higher return for the same risk level, then they would shift their investment from the subject company to that one that provides a greater level of return for a comparable level of risk. All of those factors feed into how capital flows in markets.
Do you have an example of, in terms of cash flow, an impairment following a regulatory ROE reduction?
A cash flow impairment?
In terms of the utility's capital attraction, do you have an example of reduced cash flow that you might argue resulted from an ROE reduction?
Reduced cash flow is an automatic impact of an ROE reduction. The moment it flows through rates, if you reduce the ROE, you're now applying a lower weighted average cost of capital to the rate base. So anytime a utility's ROE is lowered produces an immediate cash flow impact once those rates go into effect. So there'd be numerous cases of that occurring anytime an ROE has been lowered. And the reciprocal is true. When ROEs are increased, it has an immediate impact on cash flow once those rates go into effect. So that's automatic. It's not a case of citing an example. It's a matter of how rates are set.
Right. I'm sorry. I think my question wasn't clear. So do you have an example of an ROE reduction impairing an IOU's ability to attract capital from investors?
Well, we've seen cases where regulators have taken decisions where their bond ratings have been affected immediately. And as a result of that, their debt costs go up. We saw this in the case of Arizona Public Service a couple of years ago, where the market reacted very negatively to a lowering of the ROE by the Arizona Commission. The company was immediately downgraded, and as a result of that, one would anticipate that their debt costs go up. So it does.
Did the investors still come? Were the investors still providing capital to APS subsequent to that ROE reduction?
Some investors were. I don't know if some investors dropped out and others came in to take their place, but one can presume that the investors that came in did so, but only willing to do so by requiring a higher return on the capital it was investing in the company. And that's how the markets work.
Thank you, Mr. Coyne. No further questions from Cal.
You're welcome.
Any other cross?
Your Honor, this is Commissioner Hebner. I have a couple questions.
Oh, there you are. Okay, yes, go ahead.
Yeah, I wanted to point your attention first, Mr. Coyne. Good morning, but wanted to point your attention to your rebuttal at page 8. And looking at the last line and the first line of page 9. And you say you agree with Dr. Keim that the authorized ROE and the earned ROE are not necessarily the same as the investor required cost of equity. I know the previous attorney asked you this question. Sorry, Judge, we're at pages 8 and 9 of his rebuttal.
Okay, just hang on a minute. I'll get right there.
Very bottom of 8.
Thanks.
And then if you could just scroll down a tiny bit to get the first line of page 9. Great. And I guess my question, Mr. Coyne, is that kind of a Midwest nice way of saying they aren't the same when you say they're not necessarily the same, or do you have more nuance to that phrase that you use there?
I appreciate the reference to Midwest nice, but not at the expense of clarity, if that's what I fell into there. So yeah, Mr. Keim refers to, and as we were just discussing in my last dialogue with Cub Counsel, there can be differences between the estimated ROE, the authorized ROE, and the earned ROE, and they can arise because let me just make sure I'm understanding your question, Commissioner. And that is your question, how can they be different?
Well, I think it's more of the cost of equity. I guess I'm viewing that perhaps incorrectly as more of an input that an investor or the company kind of is looking at that cost of equity as what return do I need in order to make an investment either within the business or for shareholders within that stock, kind of what's my bare minimum that I need to get in order to make that decision. Whereas the ROE is more of an output. How much return did I earn on that equity?
Right. Okay. That's the distinction you're making. It is on the first point, the cost of equity that we estimate. My presumption is that we estimate the cost of equity using models, and the commission adopts an allowed ROE that's based on that estimate of the cost of equity. Now, when we try to, is that a perfect science? Of course not, because there are a host and numerous investors and utilities. So our models inevitably are an abstract of what's really going on in capital markets, but we take all the information that we can from capital markets to estimate what we think the required return is for investing in a company like NSPW. And then on that basis, and relying on those models, the commission, of course, sets the allowed ROE. And assuming for a moment that they're equal. And now it's up to the utility, however, to earn that ROE. And there are a lot of reasons why it could earn over or less than that allowed ROE, depending upon its rate program, its operating efficiencies, and incentives built into its rate program. It's unusual for a company to precisely earn its allowed ROE. There are usually differences.
So I guess, would you agree that there are two different concepts? And then it may be the case that the value is the same or is different.
And the value of what specifically, Commissioner?
Sorry, that the cost of equity is a different concept than the return on equity. But they may ultimately be the same numeric value.
And when you say different than the return on equity, do you mean the allowed or the earned in your question? Because those are different. So there are three different concepts: the cost of equity, the allowed, and then the earned.
Yep.
And I'm saying that the cost of equity and the allowed should be equivalent, but the commission could decide
should be the same. Okay.
Yeah. Yeah. And that's the issue I'm taking up with Mr. Keim there, that he's suggesting that the cost of equity is very different than the allowed ROE set by commissions. And he cites these papers that I refer to that suggest that commissions are setting the allowed ROEs too high in relationship to the actual cost of equity. And I take issue with that, because I don't think that those papers are reliably estimating what the true cost of equity is. Otherwise, they wouldn't reach that conclusion.
Okay, thank you. I had one other area of question, and that was around the discounted cash flow model. And you had some testimony here today about what the terminal growth rate could be.
Yes.
Our commission staff witness has estimated 2.5%. I wanted to ask whether, from your perspective, discounted cash flow models for regulated utilities should include inflation or should not include inflation as a principle.
At a minimum, they should include inflation if you are going to use GDP. The typical premise of using a multi-stage model is that we start off with earnings growth rates, and most analysts will use earnings growth rates for the first 5 years in their DCF model, because that's their availability. And then after that, you have to make a decision. Am I going to decide that the company will continue to grow at that short-term earnings growth rate, or do I want to make some alternative assumption? And for those employing a multi-stage model, oftentimes the surrogate for earnings growth forecasts from analysts is to suggest that the company will grow at GDP. But when they do so, they inevitably mean nominal GDP, the actual rate of growth in the economy that would include both inflation and real growth. And as I show on page 31 of my rebuttal testimony, when I look at the proxy group companies that I've used in my analysis, their median earnings per share growth rate over the last 12 years, which is the longest period of time over which I have this data, is 6.27%. So that's their actual earnings growth. So to suggest that they're going to go from 6.27 to 2.5%, as utilized by Mr. Tierney, is just a fraction of utility growth historically. And I just don't think it's realistic, especially if you think about all the investments that are going to be required in the industry for decarbonization and grid hardening and things of that nature. Nothing suggests that the rate of capital investment in the industry would force it to grow at a third of its historic rate or something equivalent to that, as suggested in Mr. Tierney's use of a real GDP growth rate. So that's beyond conservative. I think it's just unrealistically low.
Okay. And would you agree that in this terminology of these models, the nominal rate refers to numeric values that are not inflation adjusted? When we say nominal, that is not inflation adjusted figures.
That's correct. It's
When
including,
we say real, that refers to inflation adjusted figures.
that's right, taking out the effects of inflation. That's right. And you can see, for example, in my rebuttal testimony, to put that in perspective on page 31, if we could just look at figure 4 for a moment, if we could bring that up.
I'll get to that just a minute.
Sometimes it's easier just to look at the real numbers just to put these issues in perspective.
And you said 31?
Yes, page 31, hard copy 31, and figure 4 at the top of the page. There we go. Thank you. So you can see there that GDP has grown at a nominal rate of 4.48% over the last 12 years, while utility earnings have grown and dividends have grown between, over 6%. So over the rate of GDP nominally, and its GDP is projected to grow at 4.24% over the next several years. So what Mr. Tierney has done in using 2.5%, which is the real growth rate in GDP, is to take a fraction of nominal GDP growth and even a smaller fraction of how earnings have actually grown for these utilities. So it would be an unusual assumption to use in this type of a model, in my experience.
Okay, that's a helpful explanation. Looking at this particular table, would you generally agree that this period of time, 2010 to 2022, has been a time of very low interest rates or relatively low interest rates compared to, say, the 20 or 30 years prior to that?
By all means, yes.
Okay. And do you think that the fact that utilities had access to relatively inexpensive debt during that period may have led to higher growth rate during this 12-year period than the interest rate environment that preceded it?
From an earnings growth standpoint, is that your question?
Right. I'm just looking at the median EPS growth and median DPS growth rates here that are higher than GDP for your sample.
And to understand your question, Commissioner, are you asking, do I believe that lower interest rates were a contributing factor to this earnings growth?
During that 12-year period, right?
Yes, I believe they were a contributing factor. And as we're now in a period of higher inflation rates, higher interest rates, everything's going to cost more. So the investments that utilities are going to make in their systems are going to cause their rate bases to grow faster, all else being equal, because towers and everything else that one has to buy to invest in a utility system, from trucks to towers, will cost more because of higher inflation rates. So on the one hand, that would accelerate rate-based growth, all things being equal. But on the other hand, the higher interest rates are typically a drag on utility earnings. So I think you'll have effects in both directions as a result of these higher interest rates.
Okay. Thank you very much for your responses.
You're welcome.
Any other cross? I did have a question for you, witness Coyne. There was a comment that I made on the offered evidence list, and before we started, the utility indicated they had no questions about those comments, but I guess this one in particular it's a kind of open-ended. I wasn't sure exactly. I guess I didn't follow through exactly what that meant. And I guess I was just looking for some more information on your direct page 29, the footnote where you, for the sentence that you state that the company will invest approximately $2.6 billion in capital and about $520 million per year. and then you source NSPW. And I'm just curious if you were taking those facts from a particular document or a conversation, or what was the source that you indicated in your testimony?
Your Honor, I'll have to go back and check that specific reference. Certainly it was a company document, but I just don't recall if it was a business plan or what the exact source of that was. I agree, that's a pretty limited footnote. Perhaps if you would allow, I would correct and expand that footnote for the precise source.
And Your Honor, we've actually found the source. I can't cite it right now. It's in a different room, but it happens to be an exhibit of one of the witnesses' testimony, and we're prepared to correct that when we refile.
Okay, perfect. So it's already in the record, is what you're saying.
It is.
Okay, great. And I did have one follow-up question because we all love ROE. And it's probably something that's so obvious to everyone else that no one's asked it, and I didn't really see it particularly stated on the record so far. But as far as I know, NSPW isn't publicly traded on it as its own entity. Is that right?
That's correct. The parent company issues all equity, and that's Xcel Energy.
Xcel Energy. So, and in terms of debt, is that does NSPW go out in the debt market as its own entity?
Debt, it's different. My recollection is they do issue their own debt. Yes.
Okay. But in terms of setting ROE, what is the connection that the commission, or I guess in terms of setting ROE, what's the connection between the commission's decision here and Xcel Energy's ability to attract capital?
Good question. So when it comes to attracting equity capital, it's really based on the sum of decisions like this across all of its subsidiaries that make it attractive or unattractive to a given set of investors. So that's why we use a proxy group of other companies. We don't look at Xcel Energy directly, and we try to choose proxy companies that look like NSPW, and we estimate in the marketplace what their cost of equity is, apply it to NSPW. And if the same is done across all of Xcel Energy's subsidiaries, presumably they are earning an appropriate rate of return on each of those regulated operations.
Okay. And a decision of a regulator of any one of Xcel Energy's subsidiaries won't necessarily create a one-to-one effect on Xcel Energy's ability to attract capital. Do you agree with that?
I do. I think it would be taken into consideration in terms of how important that subsidiary is to the overall company's cash flow and income products, its credits, its credit worthiness and things of that nature. So it would always be factored into just how important that subsidiary is to the overall company's business prospects.
And to your knowledge, does the record contain that analysis?
Of the percent of parent company financials that NSPW represents?
That's correct.
I'm not, I don't believe it's in my testimony, and I would defer to, perhaps counsel might be aware if that's in the record or not, but not to my knowledge.
Okay, that's fine, thanks.
It's also the case, if I could add, Your Honor, that's one of the reasons why when we approach this work, we use the standalone principle. So we in fact try to divorce the analysis from the parent company to look at it as an independent entity and set the cost of capital for that subsidiary that's appropriate for its risk profile and investor required returns for a company like NSPW. So we deliberately try to divorce it from the parent company and all those other effects.
Okay, great. So any redirect?
No redirect, Your Honor.
Okay. Well, thanks very much. You're excused.
My pleasure.
Take care.
Bye now.
Okay, thank you, Judge. Our next witness is here with us in Eau Claire, and that's Mr. Michael Teselich.
Okay. There. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Thank you. Mr. Desalich, did you file or cause to be, I'm sorry, let me start over. Good morning. Could you please state your name for the record and spell your last name?
Michael Desalich, Deselich.
Thank you. Did you file or cause to be filed written direct and written rebuttal testimony in this proceeding?
I did.
And were the answers you provided in that testimony true and accurate to the best of your knowledge?
Yes.
Now, I have a few additional questions for this witness, Your Honor.
Okay.
Have you read the surrebuttal testimonies of PSCW staff witness Ms. Malley and Cub witness Mr. Singletary?
Yes, I have.
Thank you. Now, both of those witnesses assert in their surrebuttal in one way or another that the company's annual incentive program, or AIP as I'll refer to it here, that the earnings per share affordability trigger prioritizes shareholders' interests over the interests of customers. What is your response to that assertion?
I would disagree with that assertion. In fact, the opposite is true of Xcel Energy's AIP. We believe the interests of customers are actually prioritized under this AIP construct. Customer-focused corporate and individual AIP goals are established at the beginning of the AIP year, and scorecard tracking results are published regularly throughout the year for our eligible employees. And as I noted in my direct testimony, the priorities found on the corporate scorecard are lead the clean energy transition, enhance customer experience, keep bills low, and safety and reliability. The associated scorecard key performance indicators, or KPIs, are customer satisfaction, public safety, electric system reliability, employee safety, diversity, equity and inclusion, and wind availability. And these KPI scores are used to calculate the corporate component of the year-end AIP awards. And it's important to note that the actual EPS results necessary to determine the affordability trigger are not known until after the end of the calendar year and prior to the payment of the year-end AIP award. Thus, the employees are aware of their customer-focused KPIs that must be met for them to earn their year-end AIP compensation, and they strive throughout the year to achieve those KPIs. And additionally, the amounts NSPW pays above the target level AIP are borne by shareholders, and NSPW is not requesting recovery of those amounts through rates. Therefore, the incremental benefits to customers for exceptional performance in meeting customer-oriented goals beyond the target level imposes no additional cost to customers. So this refutes the witnesses' arguments that EPS and the AIP design put shareholders' interests above those of the customers.
And thank you, Mr. Desalich. Now, you've used the term EPS. That means earnings per share?
That is correct.
Okay, and it's the EPS, that's the affordability trigger, as you call it in the AIP?
That is correct.
Now, that affordability trigger, this earnings per share, is that one of the key performance indicators?
No, I believe the witnesses are confused a little bit with the affordability trigger as one of the employees' personal goals or corporate KPIs. In their day-to-day jobs, most employees who are eligible for AIP do not have a direct impact on the EPS trigger. And more importantly, the employees must work to achieve the customer-focused KPIs regardless of the EPS.
Okay, but in his surrebuttal testimony, Mr. Singletary indicates that employees would have an increased interest in the company EPS so as to make sure that the AIP is paid out. Do you agree with that statement?
Again, I do not. Most employees do not have direct responsibility for financial results used to determine the EPS, but they are responsible for providing great service to our customers. And as I previously mentioned, the final EPS is not known until after the AIP calendar year is closed. Therefore, it'd be challenging for those employees to make sure the company meets its EPS for the payout aside from operating efficiently and effectively while providing safe and reliable service to our customers throughout the calendar year.
Okay, now, Ms. Malley suggests in her rebuttal testimony that the company has not provided proof that it has had recruiting or retention problems as a result of the company's shareholders paying for 100% of Wisconsin jurisdictional share of the AIP expense. Do you have a response to that?
Yes. The question should not be whether or not the shareholders taking the responsibility of the AIP expense has prevented the company from recruiting or retaining its talent to meet the needs to provide safe and reliable service to customers. The real question should be whether or not the cost of market-based total cash compensation offered by the company for these employees is found to be reasonable cost of service and therefore recoverable in rates.
Okay, thank you, sir. Judge, I have no further questions for this witness.
Okay, any questions for the witness?
Yes, I do have one question.
Okay, let me just ask for interveners first.
Cub has one question, Your Honor.
Okay, let's take Cub first. Thanks.
Good morning.
Good morning.
Just a follow up on your testimony regarding the AIP. So just a yes or no question. Is it would or would not? I guess that's not a yes or no question. That's a would or would not question. Would or would not AIP be paid out to employees if the earnings per share trigger or the affordability trigger were not met? Again, were it not met, would AIP be paid out?
Sure. While that is correct, there are also the KPIs that are customer focused that are also part of the program that need to be considered here for payout.
Okay, so no, it would not be paid out were the EPS trigger
Correct.
not. Okay, thank you. That's all.
Okay. Other questions?
Yes, I do have one question.
Okay.
From PSC. You mentioned that the transition to green energy. What are some of the other desired goals covered by your non-ESP portions of your incentive plan?
I'm sorry, can you say that again?
Yeah, you had mentioned the transition to green energy.
To clean energy.
To clean energy. What are some of the other desired goals covered by your non-ESP portions of your incentive plan?
Or non-EPS portion?
How does the company determine and prioritize those portions?
I'm going to object, say vague here. I don't understand the question, so if we could put that together, that'd be great. Thank you.
Let's restate that, please.
Just one moment, Judge.
Sure. Let's go off the record. Okay, just let me know when you're ready.
Just one more second.
Mm-hmm.
Sorry, thank you.
Okay, let's
so-
go. on the record.
I meant to say EPS, non-EPS goals. So you have to meet those goals, but in addition to that, what are some other goals that need to be met?
Again, I'm concerned. I don't understand what she means by those goals. Could we break it down? I just want the record to be very clear about what we're talking about here.
Yeah, I agree. So let's just take each step that you want them to
Good.
answer.
Non-EPS goals to achieve the incentive compensation.
Sure.
And I'm sorry, but I
Just-
have to do this because we've just heard testimony from the witness that the earnings per share mechanism, the affordability trigger is distinct from the goals of the KPIs. So I don't want it on the record assumed that, this EPS is a goal. It's a trigger is the test.
Okay, sure.
Well, let's
So-
just start from scratch and ask
Sure.
the entire
Okay,
question at once. Yeah.
Yeah, and so in addition to the EPS trigger, or do you want to call it that? What are other, I guess, triggers that need to be met in order to achieve the IC? Are there any other ones?
So again, the corporate scorecard identifies the goals that are included in the AIP program that I mentioned here just a little while ago. The scorecard key performance indicators are customer satisfaction, public safety, electric system reliability, employee safety, diversity, equity, and inclusion, and wind availability.
Okay, and how is the scorecard developed and quantified?
The scorecard is developed by our corporate strategy team and broken down into segments based on the corporate priorities that are also listed on the scorecard. They're given each of the goals or KPIs are given a certain weighting, and then those are scored throughout the year, and then a final score at the end of the year based on company performance.
And do customers have direct input into that development? Or is it mostly the company that develops this?
It's a corporate scorecard, so it's developed by the corporation.
Okay, thank you. No further questions.
With the customers in mind, obviously.
Okay, any other
Thank you.
comments?
No other questions. Thank you.
Anyone else? Any redirect?
No redirect.
Okay, well, thanks very much. You're excused.
Thank you, Your Honor.
Our next witness, Your Honor, will be Mr. Terrell Zeke. He's on site with us here.
All right.
in Eau Claire, so he'll be coming in the room momentarily.
Okay, I see you there. Raise your right hand and do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Good morning, sir. Please state your name for the record and spell your last name.
Good morning, Terrell J. Zeke, Z-I-C-H.
Thank you. Did you file or cause to be filed in this proceeding written direct and written rebuttal and written surrebuttal testimony together with 5 exhibits which have been marked EX NSPW Zeke-1, 2, 3, 4, and 5?
I did.
Now, were the answers you provided in that testimony and the information provided in those exhibits true and accurate to the best of your knowledge?
They were.
Okay, and with this witness also, Judge, I have a few additional questions.
Okay, proceed.
Mr. Zeke, did you have an opportunity to read PSAW staff witness Mr. Stevenson's rebuttal testimony on the competitive response rider?
I did.
And do you have any comments on that response?
I do. I believe we have partial alignment on the proposed CR1 competitive response rider tariff.
I'm
Mr.
sorry. Could you speak up and then a little slower, please, so I can understand?
Yep, absolutely.
Maybe
Sorry.
speak towards the microphone would help.
Yeah.
So, yeah, thanks.
I'll start over. So yes, I do have some comments. I believe we have partial alignment between Mr. Stevenson and myself on the proposed CR1 competitive response rider tariff. Mr. Stevenson and I agree to increase the CR1 tariff cap to 200 megawatts. However, Mr. Stevenson's rebuttal revealed some disagreement between us over the proposed tariff language that would allow existing subscribed customers with expanding load to exceed the originally proposed 200 megawatt cap. Staff seemed to prefer a hard cap rather than allowing the company to exceed the cap under certain circumstances.
Well, has the company proposed an alternative to the 200 megawatt cap?
I will right now. The company could support eliminating the language allowing existing customer load to exceed the cap in return for increasing the cap to 400 megawatts. I talked to Mr. Stevenson and he did not seem to object or have concerns with this compromise.
And just to be specific, you talked with Mr. Stevenson about this idea of increasing the cap to 400 megawatts.
That's correct.
And that cap, well, why don't you just tell me how that, what you're proposing would look on the proposed tariff sheet? And Judge, if you could pull up exhibit NSPW Zeke-1, Schedule 6, page 3.
Off the record, I'll get to that once my mouse cooperates here. And it was schedule, repeat that again.
It's Schedule 6, page 3.
And just so you know, probably we'll have you file this as another exhibit so that we'll have that on the record, the exact language that you're proposing right now. But it's worth it to present that to everyone at the hearing as well. So let's get on the record. Yeah, I think we've discussed we're in exhibit Zich 1, Schedule 6, page 3.
Yes, and my question, just to refresh it, is can you explain to us how the implementation of the 400 megawatt cap you've proposed and discussed with staff would look like if incorporated into this tariff on this sheet that we're looking at?
Absolutely. So this exhibit and schedule shows the red line CR1 tariff I proposed in my direct testimony. The changes discussed with staff would be altering the 50 megawatts on the tariff, and that would become 400 megawatts instead of the 200 megawatts that was proposed. And then the new sentence following, the last sentence of the section being revised, would be excluded.
Okay, so what you're saying is the sentence that begins participation limits may be exceeded only, that sentence?
Correct.
That would not be in the tariff under the proposal that you've discussed with staff?
That is correct.
Okay, thank you. Can you explain, please, why it's important to the company to raise the cap of this tariff above 200 megawatts to the level that you've discussed with staff?
Yeah, it may be true as staff described that some customers can wait for a commission review and approval of a TE docket to increase the CR1 tariff cap. This is certainly not true for other prospective customers. And this is because a primary screening criteria for site selectors is often utility rates. And site selectors are those that often help large customers locate in different regions of state like Wisconsin. And this means that certain prospective customers and their site selectors will not consider locating new facilities in an area unless certain rate criteria are met. The CR1 tariff enables the attraction of these customers who have a high sensitivity to utility rates. And having a fully subscribed CR1 tariff may result in these prospective customers screening sites in the company's service territory and results in uncertainty to customers if participation in the CR1 tariff is contingent on regulatory approvals to expand the program cap. Attracting new customers and retaining large customers seeking to expand their operations within the company's service territory also serves to benefit all other customers by spreading costs, the utilities costs, across a larger number of billing units. And it's important to note that this is possible because while the participating customers receive a marginal cost-based rate on incremental load, the first 30% of their load under the CR1 tariff is always on standard embedded cost rates, the revenue from which directly benefits other customers.
Okay, thank you. I have no further questions for this witness.
All right, so I just wanted to be sure we memorialize this. So we would have a ZITch 6, which would be the revised proposed revisions to the CR1 tariff that we just discussed. So we'll mark that now. And if you can file that within the time frame for filing new revisions. Also, I just wanted to be sure the remaining changes that were proposed in the exhibit 1, will those still appear in the new revision?
That is correct.
Okay, great. Okay, so no other questions. Do we have any cross?
Your Honor, this is Commissioner Hebner. I have a quick question for the witness.
Sure, go ahead.
And it's related to this competitive response rider. Is
Okay.
there a sunset on this for customers? A number of years that they can participate in this rider before they transition to standard rates?
There is not a sunset in the current CR1 tariff.
So the 30% of their load would always be at the tariff rate. But then they would be able to remain on this rider for the length of their time as a customer at this point in time?
That is correct.
Okay. And does that 30%, is that fixed on when they become a customer, or does that 30% fluctuate with the load over the years?
Yeah, good question. So the 30% applies to new customers locating to the locating to the utility service territory. And it's fixed at the time they apply for service to the company. So that 30% creates their baseline demand level, which is fixed for their duration as a customer. For existing customers, that baseline is not fixed at 30%. It's based on their historical demand. And anything new they bring to the service territory at that location would be considered incremental and on the competitive response rider tariff.
Okay, got it. So the 30% is fixed upon the start of it, and then that level of usage never changes. So if they continue to grow above that, the new load would always be at the rate specified here in this rider.
For new customers, that's correct.
Okay, for new customers. For existing customers, it doesn't. It's different.
The baseline calculation is not at 30%. It's at their historical demand level, and then it correct that any incremental load added above that baseline would stay on the competitive response rider in perpetuity.
Got it. Okay, thank you.
And then the incremental, I'm sorry, go ahead.
Nope, go ahead, Judge.
So the incremental load is then subject to the cap, right? So after 400 megawatts, you revert to the standard rate.
Yeah, that's correct. The tariff cap language applies to, as the tariff shows on the screen, a certain megawatts above the demand above baseline levels. And I did discuss that in my direct testimony, that there's substantial billing challenges and customer confusion that would be associated with exceeding that cap. The baseline would be on standard tariffs. The next part of their load would be on the standard rates, and then any part of that exceeds that cap would be on standard rates again. And that's one of the goals that we're seeking to avoid by increasing the cap in the tariff.
Right. But the effect of the cap is the same on the new tariff.
Under the compromise and language, the new language that we'll be filing, that's correct. Just a higher cap.
Yeah. Okay. Perfect. Thanks. Okay. Any other cross? No. Redirect. I'm sorry.
Yes, I do have a question.
Oh yeah. Go ahead.
I'm sorry. I can't see who's talking.
Tara Kuntz from PSC.
Thank you.
Okay. So I have a question regarding the companies which aid in citing facilities that could be potential customers to this program. Are these companies, are they able to tell if the program is fully subscribed and help screen, I guess, NSP out of a list of potential locations?
Can you restate the question?
So the question is regarding entities that are aiding, they're aiding, I guess, companies similar to NSP in citing facilities that could be potential customers of the program. Are they able to tell if the program is fully subscribed and then screen NSP out of a list of potential locations?
I think if I'm understanding your question correctly, you're asking if site selectors have access to data that would indicate whether this program is full or not.
Correct.
I think under the proposed reporting requirements that staff have proposed, the answer to that question will be yes. Currently, the only available information that would show that would be the schedules in this rate case that show how much load is on the competitive response rider today. So that information is publicly available. I do not know whether site selectors use that information. Typically, we offer this program to customers that approach us wanting to connect and can demonstrate, as is required under the program, that they're in a competitive situation. And at that point, if the program is full, the company is not going to be able to offer them this tariff. And that at that point, they would certainly find out that the program is full. So typically what happens is a large customer will issue something like a request for proposal. I have X number of megawatts I want to locate, and they send it to every utility in the geographic area they're looking to locate. And to that, we respond with whatever criteria they would like us to respond to. And if one of the criteria is they're looking for competitive rates, we would include this in our offer, in our request, in our response to that RFP. If this program is full, we would not be able to include this in our response to the RFP. And at that point, they would also find out.
Okay, thank you. No further questions.
All right. Any other cross? No. All right. Redirect.
No redirect.
Okay. Well, thanks very much. You're excused.
Thank you, Your Honor. The applicant's final witness today is Mr. Donald Dahl, and he's with us here in Eau Claire.
All right. Hey, I see you there. Raise your right hand. We'll swear you in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Thank you. Good morning. Please state your name for the record and spell your last name.
Donald Dahl, D-A-H-L.
Thank you. Did you file or cause to be filed written direct and written rebuttal testimony in this proceeding, together with written sir rebuttal testimony, together with exhibits which have been marked Exhibit NSPW Doll 1, 2, 3, and 4?
Yes.
And were the answers you provided in that testimony and the information contained in the exhibits true and accurate to the best of your knowledge?
Yes.
Those are the questions I have for this witness.
Okay. So I did not put those new filings in the offered evidence list because I didn't have time to do that. So I did want to take a look at Doll 4. And first, let me ask parties and staff if they have had a chance to review those documents, if there are any objections at this time. So just respond if there are. Okay, so I haven't heard any, so we can accept those documents. I did have a comment though on the, oops, what did I just do? I had a comment on the exhibit filing, and that's typically I'll ask people if they do choose to use red in their tariff in their exhibits. I'm assuming red is that to indicate a negative number?
Yeah, it's a basically a checked figure.
Ah, okay. Okay, well, I think we'll just let it stand as it is right now. But I guess most people, will assume red means negative. At least some people will. And then I make them put those negative numbers into parentheses because that's another way of indicating that in case they have trouble seeing red. But maybe we're all seeing red at this point. So at this point we'll let it stand. But just be mindful of that when you're producing new exhibits. So we can accept those documents, and I think that's it. So do we have any cross-examination? Nothing. Okay. All right. Thanks very much. You're excused.
Thank you.
All right. So that's all of NSP's witnesses.
Yes, Judge.
Right. So we still have the remainder of parties and staff. It is almost noon, so we can take a quick break here. And then unless there's objections, and we can reconvene. So let's do, I guess we'll count this last bit up until noon as 10 minutes. So let's get back at 20 after 12 and we can resume, and hopefully won't take too long to do the rest of the case. So can turn off video and audio, but I'd stay connected because it may be difficult to reconnect. Who knows? All right, well, take care. I was being nice to you. Unless you have to go somewhere after this. I pushed Debbie without realizing it last time. I don't know if she told you.
No, she didn't. We don't usually expect a lunch. Most people don't take a lunch break, so.
Oh, there you go. So my fault, man. It's always my fault. It's okay.
Well, that's what I've been saying.
Yeah. Just keep telling me that. Okay. Oh, good afternoon, everybody. I have a second hand on my clock now on my computer, so no, I can stretch it exactly as far as I can. I don't know if we have everyone back yet, so I think we're here to start with Cub witnesses now.
I only see NSPW witness.
Yeah, okay, so let's just be off the record for a sec. So Lynn, I should have asked you this before. So when I spotlighted the witness, I can still see everyone. It's just the live stream that seems to, only take that square. I'm just wondering, are you looking at all speakers, or are you looking at the gallery view, or only speakers?
Well, right now, just since you switch it to NSPW witness, from the normally it's all witnesses.
Right.
But when you go on, when you pointed out specific witnesses, I could only see that witness. That's why I asked Ms. Coons who is speaking.
Right. So I wonder if that's.
Let me see if there's something.
So if you have a different way of viewing the participants, you might be able to see everyone still.
Okay.
But maybe I'm wrong. I don't know. I don't know what it looks like from your end. Can other people see the rest of the participants, or only the NSPW witness?
Your Honor, if you switch to the gallery view, then you can, the pinned witness just remains at the top, but then you can see everyone.
Right. So
and that's how I normally have it, but okay, but somebody switched it for me. So.
Oh, okay. It wasn't me. Okay, I thought maybe Okay, so now you can, because I think I still have the NSPW witness.
All right, let me just move this exhibit thing over. So that...
Okay, good. Yeah, I didn't realize you were hamstrung. Okay, but I'm going to turn off the spotlight because I don't think we'll be using NSPW witness now, but just so you know, yeah, you want to be in gallery view no matter what. I think is probably the best for you.
And like I said, I always was in gallery view until
you
did that spotlight thing, and then I kind of lost it.
Okay, so I just removed that spotlight, so hopefully you'll be seeing everyone now. Okay, so are we?
I don't have a gallery view on my options under view. I always do, but
oh, well, that's.
I have. Oh, there we are. Okay, sorry.
Okay, you got it.
Figured it out.
I know we want you to on board. Okay. All right, so we're ready to go. We have a couple witnesses available, and let's get started. We'll get back on the record, and let's call Cub witnesses.
Thank you, Your Honor. Cub calls witness Ted Callan to the stand.
Okay, there you are. Perfect. Okay, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Do.
Okay, go ahead.
Please state your name for the record.
Ted Callan.
Mr. Callan, did you file or cause to be filed in this proceeding direct testimony, errata for that direct, rebuttal and errata for that rebuttal, sur rebuttal and accompanying errata, along with 6 exhibits?
Yes, I did.
And did you also file, not noted on the offered evidence list, a revised exhibit 4?
Yes, I did.
And is the reference number for that 478167?
I do not know. I apologize. 478167.
Okay, thank you.
Yes, thank you.
And is that testimony and the information in that exhibit inclusive of your errata and the comments on the offered evidence list true and correct to the best of your knowledge?
It is.
Do you have anything to add to your testimony at this time?
I do. I have 4 different exhibits to add, which will read as X Cub Callan 7, X Cub Callan 8.
P or public, X Cub Callan 8C for confidential, and X Cub Callan 9. And these correspond to references that I made in my direct towards NSP, the applicant's responses to Cub's data requests or interrogatories. And so those are, so for Callan 7, it's NSPW's response to 2 Cub 8. And then for Cub Callan 8, it's the public response to 2 Cub 16 and the confidential response to 2 Cub 16. And then X Cub Callan 9 corresponds to NSPW's response to 2 Cub 17. So, yes.
Thank you. So Cub would like to move those into the record.
Have those been served, those exhibits?
They have not. We would be filing them and serving them after the hearing, but those are NSPW's responses to Cub 8, 16, and 17. We did refer to them in testimony. We just did not file the responses.
Okay, understood. And so the substance of those exhibits is limited to the responses themselves? You're just sharing the responses and nothing more?
Yes.
Yeah, that is correct.
Okay. Then I wouldn't have an objection to that.
Okay.
So we can look for the original documents are the ones cited in your testimony at this time.
Yes.
And then when you refile, so it doesn't look like I had you refile. Oh, you have errata for all the filings. So when you refile your testimony, please refer to those data request responses using the new exhibit numbers.
Yes.
Okay. And all right. Yeah. So this is kind of a exceptional circumstance, but because we're operating on Zoom, we don't have an opportunity to hand those documents out and review them. But since these were already filed and everyone's familiar with them and the applicant has no objections, it's fine how we're doing this now. But we do usually require that you serve additional exhibits on parties and staff prior to the hearing. So just to note that for the future, especially if you're going to be producing something new to the proceeding, but it really does apply to everything that's coming in after the deadlines for filing.
And Judge, I'd like to reserve on behalf of NSPW the opportunity to object if for some reason the substance of these exhibits deviates from what's been represented here. I have no reason to doubt that the way it's been represented is true. I just want to make sure we reserve that potential.
And that's fine. So what we can do is, I'm assuming we'll have these filed on the deadline to file additional, well, I guess it was really the deadline for filing revisions, which should be Wednesday. So at that time, we will, well, let me say it this way. When those exhibits are filed, we'll treat them as coming in on a motion to offer additional evidence. So that there'll be a 3-day period to object. And if no objections are filed, they'll go in the record automatically.
Okay.
So.
Okay, thank you for that.
Okay.
Mr. Callan, do you have anything additional to add at this time?
I do not.
Okay, Mr. Callan is available for cross or questions if there are any.
Okay, I just wanted to be sure the exhibit 8 is going to be the representation of 2 Cub 16.
Yes.
Okay.
And there was a public response and a confidential response.
Yes. Okay, perfect. Okay, so any cross?
None from NSP.
Interveners and commission.
No questions.
Okay. All right. Thanks very much. You're excused.
Thank you.
All right. Cub calls Corey Singletary.
Well, there you are. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Corey Singletary.
Mr. Singletary, did you file or cause to be filed in this proceeding direct errata for that direct rebuttal testimony, surrebuttal testimony with errata, and 3 exhibits?
That's correct.
And is that testimony and the information contained in those exhibits true and correct to the best of your knowledge?
They are.
Do you have anything to add to your testimony at this time?
I do not.
Okay, Mr. Singletary is available for questions.
Questions from the applicant,
None.
interveners? Not hearing any, and commission staff.
No questions.
All right, thanks very much. You're excused.
Thank you.
All right. Cub calls Dr. Steve Keim.
There he is. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Stephen Keim.
And Dr. Keim, did you file or cause to be filed in this proceeding direct testimony with errata, rebuttal testimony, surrebuttal, and 1 exhibit?
I did.
And is that testimony and information contained in that exhibit true and correct to the best of your knowledge?
It is.
And Judge Newmark, we received a fair amount of sir from the applicant and would like to present sir in question and answer format at this time.
Yep, that's fine. Go ahead.
All right. So Dr. Keim, did you hear the sir rebuttal of NSPW's witness, Mr. James Coyne?
Yes.
And did you hear his responses to my questions and the questions of Commissioner Huebner?
Yes.
So Mr. Coyne suggests that your reliance on Morningstar to develop an initial estimate is inappropriate. Do you recall that testimony?
If I could clarify, an initial cost of equity estimate.
Yes.
If that's your, yeah, yes.
Not ROE, cost of equity.
Yes, that's correct.
Okay. And what is the cost of equity that Morningstar estimates for NSPW's parent company, Xcel Energy?
7.5%.
Okay. Mr. Coyne suggests that this estimate cannot be relied upon because it's the same for all utilities, and in fact, the same for all low-risk stocks. Did you hear that testimony?
I did.
And do you have any comments on that testimony?
Yes, that is exactly what should be the case. Basic finance, which has been in place since the 1950s, is the cost of equity for all firms in an industry is about the same, and even for firms outside the industry, if their risk is the same. So rather than getting it wrong, Morningstar gets it exactly right. That's what it should be. It should be the same or approximately the same. And we see that they're very consistent on that. It shouldn't surprise us that Morningstar, which is an investment advisory service, gets that correct.
And where does Mr. Coyne suggest we get a cost of equity estimate?
Well, he suggests we go to Value Line, but there's a problem with that because Value Line doesn't provide cost of equity estimates. It only provides return on equity estimates. And again, back to basic finance principles, I cited to an article in my in rebuttal by Ezra Solomon, who said, don't confuse the return on equity and the cost of equity. They're not the same conceptually. They're almost never the same numerically. So Mr. Coyne jumps right into that morass. He actually then goes to a return on equity to estimate a different variable. That's just a non sequitur.
Okay. Can you, are you aware, or can you discuss problems with utilities accessing capital from investors?
I'm sorry, I didn't hear the first part of, if you asked the question, I didn't hear the first part.
Do you have any comments on the challenges that utilities might face accessing capital?
Yes, you asked Mr. Coyne a question about whether any utilities did. He suggested that Arizona Public Service, which is a subsidiary of Pinnacle West, was downgraded because of a decision, but that's actually not responsive to your question. The question was, did they have any problem accessing capital? And they absolutely not. If you just look at their cash flow statements, they had an ROE decision of 8.7% in 2021. Well, in 2020, they added 1.3 billion of capital investment. In 2021, the year that they had the bad decision, they added 1.5 billion. The next year, they added, after this bad decision, as it's been called, they added 1.7 billion. And this year, they're on track to add 1.8 billion. In other words, just as finance theory would predict, the ROE has no effect on the ability to attract capital. And Arizona Public Service, which is offered up without evidence as being sort of the poster child for this, if you simply look at the data, and that's all we ask the commission to do. Look at the financial market data look at Morningstar, look at cash flows. You will see that finance principles are borne out, and Mr. Coyne's testimony is an abstraction and ad hoc deviation. It doesn't match the data. So, and this is a perfect example. Arizona Public Service has had no trouble raising capital. In fact, its capital expenditure path is exactly the same as it would have been at a higher ROE.
Okay. So in the line of questioning from the applicant's counsel, there was a suggestion that you were testifying that ROE should be set such that market equals book value. And what do you have to say about that?
So that's contrary to my testimony. My testimony says if you estimate the cost of equity correctly, and this is uncontroverted in finance, if you estimate the cost of equity correctly and you were to use that number as the ROE, you would drive the stock price to book value. That's, as I said, that's finance principles. My testimony says that that's the only thing a cost of equity model can do. But notice that my cost of equity estimate is 7.5 to 7.9, and my ROE recommendation is 9.3%, 180 basis points higher. Why? It's a fundamentally different variable. All the cost of equity can do, models can do, if you do them correctly, is give you a number. It should be like in the sevens. That what number do we think would drive Xcel Energy stock price to book value? Well, something in the sevens probably would do it. Okay, now I know what the cost of equity is. Okay, I'm getting ready to set the return on equity. That's the bare minimum. In fact, I think that's too low. But we are so far from that minimum that of course we would want to move toward it. And that's my testimony, the company has misrepresented, or Mr. Harmiden misrepresented my testimony. I never said that they should be set equal to 1, that should be the commission's goal. I do say that Mr. Coyne's models that estimate returns on equity that would, or cost of equity that would not drive the market to book to 1 are by definition inconsistent with finance. So the company and Mr. Coyne are still not understanding this basic financial framework, the standard one. Market to book equals 1 if ROE equals cost of equity. Return on equity is a policy decision. It's not a finance decision. The commissioners aren't hired to do math. They're hired to make policy, and that's exactly how my testimony proceeds.
Do you have any comments on the trade-offs along those lines of policy choices? Do you have any comments on the trade-offs between shareholders and customers in that context?
Yes, the court is very clear about the ultimate trade-off Mr. Coyne talks about the financial categories, which are actually a subordinate list. It's investors versus customers. That's the overarching principle. And then there's some investor perspectives underneath that. But the ultimate objective is a balance of investor and consumer interests. And the court goes on to say, even if the utility has done everything right, has been prudent, has done everything right, and you've measured its costs correctly, we still must test to see if the rates are affordable. And if they're not, then the rate should be set below the cost of service. Now, I am not suggesting anything like that here, but what you can see the court is saying is if one party, the customers or the investors, is superior or paramount, it's the customers. So that's really, that's why in a period where interest rates might be rising like they have been today, we still should be driving the return on equity down toward that cost of equity. That's actually just good public policy balancing of interests.
Okay. And do you have any comments on long run growth?
Yes, I actually have a table in my SIR rebuttal, Your Honor, if you would like to pull that up at page 17 on my SIR rebuttal testimony.
Off the record for a second here.
Thank you. That's it right there.
Okay, back on.
So Mr. Coyne presented evidence, 12 years of data. I have 5 times as much. I have 60 years of data. And he, again, violates, this is not a debated point. He says that utilities can grow faster than GDP in a long run sense. That cannot be true. It never will be true. And if we look at this table, we see that the GDP, the nominal GDP, which is real inflation, over the 60-year period grew at 6.4%. Dow Jones Utilities grew at 3.7%, which matches the inflation rate. This goes to his criticism of the staff's long-run growth rate of 2.5. That's actually a good growth rate. That 2.5 actually is an inflation rate. It's because utilities don't grow at GDP. So while we could actually manipulate, or that's not the right word, we can modify the DCF model. Maybe we need a 3-stage or something where we have analyst growth and then a moderating growth. But in the long run, should be something close to inflation. The basic principle of finance is that the GDP growth rate is the maximum growth rate, and most companies will not grow that fast, especially utilities. So the evidence is, again, consistent with finance principles. We should not be using GDP as a terminal growth rate for utilities. They're just not going to grow that fast in the long run.
Okay, thank you. Do you have anything to add to your testimony beyond?
Well, clearly, Mr. Coyne and I have a lot of disagreements. I'm not going to rehash every one of them here. Nothing that he said changed anything that I say. I am using a corporate finance frame. He is not. He's using an ad hoc frame. And the data and the models, if you do them correctly, match up with what I say. So I'll stand by my testimony.
Okay, Dr. Keim is available for cross-examination.
Applicant, any questions?
No questions.
Other interveners? Commission staff?
No questions.
Okay. So I did have a clarifying question for you, Dr. Keim, and I think you used the phrase cash flow, and I think Attorney Corbin Faris used in her question was asking witness Coyne about cash flow. I think maybe the parties are speaking, not connecting on that phrase. Did you hear Mr. Coyne's answer on that? I think he mentioned cash flow is set at the date the rates are set. Yeah. And maybe you're using cash flows in a different way. Can you?
Sure. Actually, I agree with Mr. Coyne's response to Ms. Ferris's original question, which is, will it affect cash flow? He's exactly right. As soon as you change the ROE, the cash flow that the utility generates is a function of its ROE. But her second question was the one that was the relevant one, which was raising and attracting capital from the outside. So that's a cash flow as well. So Your Honor, your question is good. The internal cash flow, how much money the company generates, that's a function of ROE. Mr. Coyne and I agree on that. But does the ROE affect the ability to raise cash from the outside, which is external cash flow? That's where the controversy is. And I say there's been no evidence that there's any problem in that regard. Is that clarifying, Your Honor?
That is, so the proper terminology would be internal versus external cash flow.
Yes, that would clarify it, I think.
Okay, great, thanks. All right, so any redirect? No? Okay, well, thanks very much. You're excused.
Thank you.
All right, that's all Cubs witnesses. So we can take Renew.
Hi, Your Honor. Renew would like to call Mr. Francisco Sayo.
All right, I see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Good afternoon, Mr. Sayu. Could you please state your name, spelling the last name?
Good afternoon, Francisco Sayu, spelled S-A-Y-U.
And did you cause to be filed written direct along with exhibits Renew, Sayu 1, 2, and 3?
Yes, I did.
And is all the information offered in your testimony and those exhibits true and correct to your knowledge, including any alterations or revisions discussed?
Yes, it is.
And this is a style point, but like to call a spade, there was the way you approached that was just like, I think that was
Hang on,
fine.
Corey. We got you on the off the record. I'm just going to mute you. Okay. Get the inner workings of the party's strategy here. We don't need to hear that. Okay, let's get back on the record. Let's just have the court reporter repeat that last question.
The question is, and is all the information offered in your testimony and those exhibits true and correct to your knowledge, including any alterations or revisions discussed? Answer, yes, it is.
That's correct, Your Honor.
Okay, so back on the record, go ahead.
Your Honor, I'd ask that these exhibits be accepted into the record.
Yes, they are. Thanks.
Okay, the witness is available.
Any questions starting with the applicant?
None.
Other interveners? Commission staff?
No questions.
All right, thanks. You're excused.
Thanks, Your Honor.
All right, take care. Let's see, I believe Walmart will be filing by affidavit if the highlights there mean anything anymore to me. So we can skip, and WIG as well. So let's just skip over to commission staff.
Good afternoon, Your Honor. Attorney Mark Ruskevich appears for commission staff. Commission staff will be calling Jennifer Malley, please.
All right, I'll wait for her to appear. Oh, I see her on. She's attached to Zoom, but not unmuted yet. You want to get her attention?
Give me a second.
Okay. Go off the record.
Now can you see me or hear me? I hit
Hi.
unmute a bunch of times and I'm trying to share my screen for my
Having
video.
trouble with the screen. Yeah, we can hear you.
Well then, let's try this.
Oh, there you go.
Now can you see?
Yes, we got everything there. Okay, perfect.
Okay. Sorry about that.
That's all right. You were second on the list, so who knew? All right, let's get on the record. I'm going to swear you in. So raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
You do?
Okay, and go ahead.
Please state your name for the record.
Jennifer Malley, M-A-L-Y.
And what is your position at the Public Service Commission of Wisconsin?
I'm a public utility auditor.
And did you file or cause to be filed direct testimony and rebuttal testimony in this proceeding?
Yes, I did.
And did you also file exhibits marked 1 and 2 in this proceeding?
Yes.
Do you have any additions or additional corrections to your testimony or exhibits at this time?
Yes, I will. I plan to submit 2 delayed exhibits that were referenced in my direct testimony. One related to the staff data request responses and the other related to public comments.
Thank you. If you were asked the same questions today, would you provide the same answers that you provided in your testimony, withholding any corrections or additions that have been discussed today?
Yes, I would.
All right, thank you very much. The witness is available for cross.
Okay, any questions? We'll start with the applicant
No, sir.
and interveners. No, and that's it. So there you go. Thanks very much. You're excused.
If it pleases the court, Your Honor, I would like to turn things back over to my colleague, Kara Coons, please.
All right, that sounds good.
Good afternoon, Your Honor. Kara Kuntz for the Public Service Commission. I would like to call Mitch Ori.
Okay, just a minute here. All right, I see you there. So let's swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead. So, yeah.
Please state your name for the record.
Mitchell Horry.
What is your position at the Public Service Commission, Wisconsin?
My position is the Focus on Energy Performance Manager.
And did you file or cause to be filed written, direct, and rebuttal testimony in this proceeding?
Yes, I did.
And are the statements and representations in your testimony you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
I do not.
Your Honor, the witness is available for cross-examination.
Okay, applicant, any questions? Applicant, questions for the witness?
No, no questions.
Okay, interveners.
None from Kelly.
All right, thanks very much. You're excused.
The commission would like to call Reed Tierney.
There you are. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
Okay, go ahead.
Please state your name for the record.
Reed Tierney.
What is your position at the Public Service Commission, Wisconsin?
Public Utility Financial Analyst.
And did you file or cause to be filed written and direct rebuttal testimony in this docket together with exhibits marked 1 or exhibit marked 1?
Yes.
Are the statements and representations in your testimony and exhibit you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
I do not.
Your Honor, the witness is available for cross-examination.
Okay, any questions from the applicant?
No questions, Judge.
All right, interveners? No, all right, you're excused.
Judge,
Thanks.
hold on, Judge. This is Commissioner.
Okay.
Just wanted to double
ahead.
back on some of the conversations with the previous ROE witnesses here.
Sure, go ahead.
Good afternoon, Mr. Tierney. Were you here and present for the discussions of Mr. Coyne and Dr. Keim related to ROE today?
Yes, I was.
Do you stand by your 2.5% for your terminal growth rate in your DCF model?
I do, yes.
Can you add any explanation as to why you feel that is an appropriate number?
Yes, that is an estimate of United States GDP growth in real terms. In the as a terminal growth rate, were the utilities long-term growth rate to exceed that? You know, what that would mean would be that the utility would, on a long enough time scale, overtake the entire United States GDP in terms of size. So anything above that number, in my mind, is renders the model nonsensical.
Okay, thank you very much.
All right, so that's it then. Any other questions? No?
From
All
the
right. That was a no?
Nope.
No. Okay. All right, great. Thanks very much. You're excused.
Right?
Thank you.
The commission would like to call Mike Ritzema.
Okay, see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Please state your name for the record.
Michael A. Ritzema.
And what is your position at the Public Service Commission of Wisconsin?
I'm a public utility auditor principal.
And did you file or cause to be filed written direct and sir rebuttal testimony together with an exhibit marked 1?
Yes. And I will be filing a delayed exhibit in regard to the market price updates and the other updates that are provided for in testimony.
Are the statements and representations in your testimony and exhibit you filed in this case true and correct?
Yes.
Your Honor, the witness is available for cross-examination.
Okay, questions of the applicant?
None, sir.
Interveners? No? Okay, that's it then. You're excused. Thanks very much.
The commission would like to call Jason Stevenson.
There you are. Great. Okay, looking very suave there. Thank you for meeting the occasion. Let's swear you in. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name for the record.
Jason Stevenson.
What is your position at the Public Service Commission of Wisconsin?
I'm a public utility rate analyst.
And did you file or cause to be filed written, direct, and sir rebuttal testimony in this proceeding together with exhibits marked 1R and another one marked 2?
Yes, I did.
Do you have any additions or modifications to your testimony at this time?
I will be filing a correction in my direct testimony, correcting 2 minor errors discussed by Judge Newmark in the offered evidence list.
Okay. And are the statements and representations in your testimony exhibits you filed in this case true and correct?
Yes, they are.
Okay. I have another question for Mr. Stevenson.
Sure, go ahead.
Have you had an opportunity to review the sir rebuttal submitted by Mr. Donald Dahl from NSPW filed on September 21st, 2023?
Yes, I have.
And do you have any comments on the revenue allocation for the GT2 large firm service class?
Yes, I do. I'd like to start by saying I appreciate the additional information provided by the applicant, and the commission may find his updated revenue allocation for this class and the minor subsequent effects of that reasonable.
Okay. And do you have any comments on the rate design?
Yes, I do. I agree with the adjustments proposed by witness Dahl on those minor corrections.
Okay. Your Honor, the witness is available for cross-examination.
All right, any questions? Start with the applicant.
None from the applicant.
Interveners.
Your Honor, this is Commissioner Hebner. Just a quick question.
Okay.
Good afternoon, Mr. Stevenson. Were you here for the testimony of Mr. Zeke for the applicant?
Yeah. Yes, I was.
Okay. And is it also your understanding that the tariff, I think it's CR1, would not have an end date for customers?
Yes, that is my understanding.
Okay. And is that common from your knowledge of, well, let me take a step back. Are you aware of any other utilities that have a tariff that's similar to this?
I believe the other investor-owned utilities do have competitive response riders, but I am not perfectly familiar with them.
Okay. And that may preclude answering my next question, which is whether you're aware of any of those kind of analogous tariffs from other utilities, if they have end dates to them or not.
I would have to look it up to confirm, but I believe other ones are similar in not having specific end dates for the customers on them.
Okay, thank you. That's all my questions. Thanks.
All right, thank you. Okay, so let's see, we asked everyone else. So any redirect from commission staff?
No, Your Honor.
No, I don't think so. I don't know why I asked that.
Oh,
Okay, great. Okay, well, take care then. You're excused.
Thank you.
That's all of our witnesses. I believe so. So, and I just wanted to mention, I missed the Stevenson 1R filing. So I'm like you see on the offered evidence list now, I'm just replacing exhibit 1 with 1R. And it's our practice and should have been followed in all these exhibit filings, that when there's a filing made to an exhibit or refiling, that when it's served to parties and staff, that there should just be an explanation of what the changes are in that service email. It's a unwritten practice that we've done for years. So if that's something new, then just please note that for the future. Otherwise, I think we have everything set. We have the post-hearing schedule in place. Any questions now about schedule going forward or refiling process? No? All right. Well, thanks everyone for attending and appreciate everyone's participation and the intelligent information we got here today. So take care, everyone. We're adjourned.
Thank you.
Thank you.
You-